Hi, and welcome to our presentation on torts. This presentation was brought to you by the members of Group 6. Today we're going to be giving you a brief introduction on what torts are and different types of them. Now you might be asking yourself, what is a tort? A tort is translated from the French word meaning wrong. A tort is a civil wrong or wrongful act, whether intentional or accidental, which results in some form of harm or loss. Now this is just a shorter definition from the one you see in front of you on the screen. Now here's a brief introduction on the history of torts. During the medieval period, tort law could be seen through the Germanic system, in which required compensatory fines for one's wrongdoings. Some of the first torts filed were trespassing and strict liability, resulted from the increase in transportation, such as carriages, causing collision and carelessness.
Now, let's talk about the different types of torts. We have intentional tort, we have negligence tort, and we have strict liability tort. Intentional tort need to show fault. Negligence need to show fault, and it could be gross or vicarious. Strict liability, no need to show fault. First, let's talk about what is an intentional tort. We have three different definitions. An intentional tort is when an individual or entity purposely engages in conduct that causes injury or damage to another. Intentional torts are wrongful acts that injure or interfere with an individual's well-being or property. Intentional torts are torts in which the defendant possessed the intent or purpose to inflict the resultant injury. Examples of intentional torts would be assault, when a person commits an assault by threatening to harm an innocent person. Next, we have battery. Is the unlawful, unwanted touching of another person. False imprisonment, interfering with a person's right to move about freely. Conversion, a thief or trespasser may be guilty of conversion because the action may be maintained whether or not the property was lawfully acquired at the outset. Intentional infliction of emotional distress must be caused by conduct that exceeds all bounds of decent behavior. Fraud. Fraud is a wrongful or criminal deception intended to result in financial or personal gain. Most common types of frauds are check and credit card fraud, internet sales, website misdirection, charities fraud, identity theft, and insurance fraud. Trespass, entry to a person's land or property without permission. And last but not least, we have defamation. It's a legal term that refers to any statement made by a person, whether verbal or printed, that causes harm to another person's reputation or character.
Intentional tort. I have a friend who was a victim of assault. She got assaulted at a red light. A couple guys came and opened her car doors, threatening her that if she called the police or screamed, they would hurt her. They ended up taking her purse, all her belongings from the car, and her phone as well, so she couldn't call the police.
So under negligence, there is a specific code of conduct which every person is expected to follow and a legal duty of the public to act a certain way in order to reduce the risk of harm to others. Failure to adhere to these standards is known as negligence. Also, a failure to behave with the level of care that someone of ordinary prudence would have exercised under the same circumstances. The behavior usually consists of actions, but can also consist of omissions when there is some duty to act. Basically, a duty to help victims of one's previous conduct. There are 5 basic elements necessary to prove a negligence case. Some of these would be: defendant owed a duty of reasonable care, defendant did not behave in a reasonable manner to demonstrate care, plaintiff suffered an injury as a result of the defendant's actions or inactions, the injury caused actual damages, and proximate cause, defendant's actions or inactions, were the cause of the injury. There are two types of negligence. One would be gross negligence, which is when an individual acts unreasonable or does something that a reasonable person would not do, thus resulting in an injury. The defendant willfully showed a complete disregard for another person's safety. The second type of negligence is vicarious negligence. It is when an individual fails to take reasonable action to prevent a harm from befalling another person. The defendant is held liable because of a failure to responsibly supervise another person or animal that caused the injury. Unlike intentional torts, negligent cases do not involve deliberate actions, but instead are when an individual or entity is careless and fails to provide a duty owed to another person. The most common examples of negligent torts are cases of slip and fall, which occur when a property owner fails to act as a reasonable person would, thus resulting in harm to a visitor or customer. There are two types of negligent cases, as I explained earlier, gross and vicarious. Some examples of gross would be, as said, slip and fall accidents, car accidents, truck accidents, motorcycle accidents, and so on. Vicarious examples would also be car accidents, truck accidents, motorcycle accidents, pedestrian accidents, and bicycle accidents.
At Radisson Bay, there was an act of negligence during surgery. When patients go in for any type of surgery, they are nervous and stressed out as is, and they trust the surgeon 100% to cut them open and fix what is wrong, not to make them worse. At Radisson Bay, there was a case where a patient went in for brain surgery, and it was the resident's job to prepare him for surgery. The resident had marked the opposite side of the head that needed to be operated on. In reality, the surgeon should triple check the patient's name and the place where they are being operated on, so there are no mistakes. This is definitely a negligence case on both the resident and the surgeon. This patient ended up coming out of the hospital worse than he went in. He lost partial vision on the left eye, and he might be disabled for life.
So some types of strict liability torts are defective products, animal tax, and abnormally dangerous activities. For product liability occurs when a product is considered unsafe by design, instructions, or warning. The manufacturer must know the defect by the time it left the manufacturing plant. For animals owned or possessed, the owner or person in possession of certain types of animals is liable for injuries if the animal causes injury to another person or animal. This may include livestock like cows, horses, bulls, or goats. Abnormally dangerous animals also fall under this category and may include snakes, tigers, monkeys, or bears. You may think wild animals are not included because, well, they live in the wild, but that's not true. If a person is in possession of a wild animal or has wild animals on their land, like animals that are housed at a zoo, and the animal causes injury, liability is assumed. For abnormally dangerous acts, another form of strict liability comes with engaging in abnormally dangerous acts, and an abnormally dangerous act can be defined as an act that carries a substantial risk to oneself and another's personal property and physical being. That's a plenty of mumbo jumbo. Think pyrotechnics, nuclear power plants, and blasting rocks with dynamite. Some examples of product liability would include chemicals and cosmetics, which are defective household chemicals, and cosmetic for personal hygiene may be targeted for consumer lawsuits should they injure someone. In these claims, the plaintiff must provide evidence that the manufacturer or vendor had prior knowledge or should have been aware of these product side effects. Next, food and agricultural products are all mass-produced food, beverages, and agricultural products, which is basically crop care, livestock food. Well, basically, they may be subject to product liability lawsuits if they are contaminated and cause food poisoning or other illnesses. Oftentimes, if the claimant can establish that a law was broken, such as a sanitary standard or restrictions on pesticides, it could be proven that the defendant exercised some level of negligence. Under product liability also stands machinery and tools, and the use of faulty machinery and tools can result in serious injury. If this damage was caused by a product defect or failure to provide sufficient notice about a risk in the product, the manufacturer or vendor could be held accountable. Defendants involved in these cases are also required to inform consumers of the potential dangers that coincide with misuse of their product if they couldn't reasonably have predicted that the product could be used inappropriately. Also, medical products and devices also stand under this, but it can be very difficult to decipher between cases concerning medical product liability and medical malpractice. Attorneys with a background in these areas of practice can counsel claimants on the applicable laws. Also, pharmaceutical products are under here, as drug manufacturers must conform to Food and Drug Administration's, which is the FDA, regulations regarding the fabrication, promotion, and sales of a product. However, if a drug is defective, this will override the fact that the company followed all the FDA guidelines. It is the responsibility of the drug manufacturer to alert consumers and doctors of all potential side effects. Now, under abnormally dangerous activities, it's very and highly risky and could cause major harm to an individual or their property. It is also not recognized commonly. To add, car recalls also fall under stricter liability, as automobile manufacturers have the responsibility to design their vehicles to guarantee driver and passenger and pedestrian safety. Automobile components manufacturers and automobile manufacturers themselves can be named as defendants in a product liability suit. Defendants may raise contributory negligence as a mitigating factor to minimize damages in these kinds of cases if the plaintiff chose not to wear a seatbelt, strapped a child in the seat improperly, or was driving recklessly or under the influence.
So to basically go over what we talked about earlier, we went over what is a tort, different types of torts being intentional, negligence, and even strict liability. We went over different examples. For intentional being assault, battery, conversion, or even trespassing. For negligence, slip and fall accidents, pedestrian accidents, even medical malpractice were some of them. And finally, strict liability. Strict liability being alcoholic beverages or dog bites in specific. Thank you for visiting our presentation with us. Feel free to rewatch any part of it if you need to learn some more.